which does not warrant any investigation. If it is in the white area, your lordship will say yes. It doesn't warrant any investigation. That's the object of a filtration process. But this case, my lord, is in the gray. I mean, it's all right to say one way or the other, but we are at the stage of inquiry. Now, my lord, please look at the other dates. Your lordship will kindly look at.
No, you said there is a needle of suspicion.
Yes.
Is it a needle in a haystack or what?
I would not say it's in a haystack because, my lord, needle in a haystack is possibly something so trivial. We use that expression, my lord, normally to convey a very trivial, a very small thing, a very something so insignificant.
It's not that.
This is not that. Because it concerns purity of public administration. I can understand, my lord, normally this expression pin in a haystack is only to convey something very trivial.
That's why I said, what kind of needle?
No, we don't know. It requires to be examined. The very fact that there is an allegation that has been made of this magnitude, and prima facie here is Devraj, who was not the owner of the property. He makes the application. At his instance, all this is being done. And he conveys the property in favor of the petitioner's brother-in-law, who gives it to his sister. And in a situation where sites have already been formed, now please look at that, my lord. Please look at now that issue. Your lordship may kindly now go to seal number 15. 13, no?
12. Seal number?
My lord, kindly see, my lord, seal number 12. My lord, in 2003, despite survey number 464 is denotified, MUDA forms layout, parks and roads. Sites are allotted by MUDA to various persons. Now, my lord, then comes Devraju, who says, I am the owner of the property. You have sold my land. He sells the property in favor of the petitioner's brother-in-law. And then, my lord, there is an order of conversion. And then, my lord, there is a gift in favor of his sister. It is on the basis of these documents that the sister now says, please give me compensation / alternate sites. Now, please look at that. Please look at the item number 16. 23/6/2014. Representations made by Parvati for compensatory sites. This is the representation she gives. Now, if an ordinary citizen had made an application like this, I asked myself,
No ordinary person made? No, along with this, there are other applications.
We have
No other application.
Nothing on record. Nothing on record. We don't have anything on record. Nothing on record.
Then why sites are distributed to everybody?
No. That is the sites which were distributed on somebody else's property to various persons. I'm talking about whether the real owner of a property which had been used by a public authority without going through the process of acquisition.
Right.
No such instance. This is the only instance.
Right.
Now, my lord, please look at, if an ordinary person had made an application like this, what would have been the attitude or the approach of the authority? Look, tell me who you are. What is your source of title? Please prove your title before I can even look at your representation.
And a mandamus before this court.
If that's not done, a mandamus by your lordships.
Direction to
Exactly.
consider.
Exactly, my lord. Your lordships are right. Consider we have hundreds and thousands of cases where representations are made, not considered. Your lordships issues mandamus saying do it within 3 months, 4 months. No, all this is not necessary in this case, my lord. It's not necessary for obvious reasons. The reasons are not far to see. That is what is required to be examined. What would the authority do if there was a representation by an ordinary citizen with respect to this, assuming that they're taking action, not sitting over it? They would say, look, there is a communication sent by one Parvati. Now, who are you? We don't have your name at all on record. We don't know who you are. Please prove your title. No such exercise. Nothing done. Straight away, now please look at, then the rules are amended, make it 50-50. as of 11/2/2015. It is on the basis of this rule of 2015 that 50-50 compensation is given. My lord, I have two as
50-50
that is,
compensation.
my lord, 50% of the extent of land which has been unlawfully
So
occupied.
3.16 acres andre about
Yes. About
half of that.
half of that. That's the formula. That's the formula in this new amended rule.
Hmm.
Now, my lord, if a property has been acquired and the compensation has all been deposited, the question of even granting one side does not arise. Property has become the property vested in the government. Where is the question of denotification? Now let us keep that aside for a moment. With respect to which rule will you take a decision on the representation that has been made, my lord, on 23/6/2014? It obviously must be with respect to the rule that existed at the time when the allotments were made.
60-40.
Exactly.
Hmm.
My lord, your lordship may kindly see when the allotments were made to various persons, my lord.
2004.
2004. I asked myself, how do you apply 2015 and give 50-50? If the encroachment or the illegal occupation was at that point of time, which is the rule which you will apply for the purpose of determining whether a person is entitled to, and if so, how much? By way of a
You accepting 60-40 entitlement?
assuming, without considering, first submission is that not entitled to anything. No, of course not, my lord. Even 60-40, even two sides is not there. The question of my accepting, my lord, not accepting is not the real issue.
No. By submissions, I'm asking.
No, my lord, I don't. Of course not. I am saying that nothing was to be done. But in this case, look at this way in which it has been done. How do you give this 50-50 on the basis of 50-50, which was a 2015 rule, in respect of what is a wrong utilization of the property in 1998? I ask myself, how can it be done that way, my lord? Which is the provision under which they can give this 50-50 rule and give these 14 sites? There is none. It's a submission I would make for your lordship consideration. Because your lordship will kindly see, my lord, that all these sites were allotted. When?
19 allottees in the year 2004.
19 allottees in the year 1900?
2004.
2004, my lord. Yes, your lordship gets it.
2004 alla?
2004. 2003, my lord. 2003.
3 or 4 are.
3 na 4? Oh.
That's why I said he has threadbare covered everything.
Now we have produced one document. Give me page 111.
2009, my lord,
Give me
came
111.
to be allotted.
On continuous process.
My lord, we have produced.
No,
a
it started at 3, sir, then ended at 9.
Continuous process. Continuous
Available. In a, all, I can.
Say they're allotted.
All right. Now, how does 2015 amendment apply? How did you apply this 50-50 rule? Well, everything can be overlooked for obvious reasons. You did not find out as to what is the title of Parvati. You did not go into the question as to whether there can be a denotification when the property is already vested. You did not go into the question of how many sites to be given, whether you will apply the 50-50 rule, 60-40 rule, 2 sites, nothing. How many times do you overlook? And my lord, your lordships have said it a number of times that where repeated mistakes are made, it leads to a conclusion of malafide. My lord, one order which is wrong, my lord, we don't allege malafide, and even if you allege, your lordships will not accept. But even with respect to a court, your lordships have taken the view that if repeated orders are made in the same case which is wrong, then there is a ground for malafide. Now, how many times are the mistakes being made? Now, your lordship may kindly look at the next aspect as to what happens, my lord. Please look at serial number 19.